that means getting rid of the idea of setting up an authorized individual entity or a sole partnership entity, as it may be referred to in other countries. The best way to go forward is setting up a limited liability company, but there's one particular aspect that you need to take into account. The moment you should start setting up the company is the moment where you start to see some headway related to creating a product market fit. That may mean, for instance, you're either starting to sell the product that you are building, even if you're only selling to a limited number of users or customers at the beginning, or the fact that, for instance, you're raising an investment and that proves that you already have some traction, at least in the sense of an interest from the investor, and the investment needs to be raised using an entity. So it's usually a company, and especially in the Romanian space, it's a limited liability company. So I think that's the best way to approach it. And another important note is, if you're doing it with other founders, so you're not a sole founder at the beginning, make sure you put down some objectives around running your business and the timeline to reach those objectives. The idea is, if from the get-go you decide you want to start a company and you're not necessarily sure about how things are going to happen, and you're not sure about each of your commitment or of your founder's commitment, you need to have some clear ideas about where you're heading to. And that's usually a moment where you need to put down some ideas about the objectives, about the key responsibilities of everyone in the team. And why not maybe even put those ideas into a shareholders agreement, and some of them are going to be reflected also in the articles of incorporation of the company. So that's just to give you a little bit of idea how to approach this subject. To sum up, that's really important, because it saves you a lot of headache down the line when, let's say, in 6 months' time or 1 year's time, one of the founders is not really that engaged in running the business. And you need to have a clear understanding of and maybe a clear expectation of how that's going to unfold and how that is going to affect the share capital of the company. So understanding that some of the founders may exit the company sooner or later. Usually it's rather sooner, especially for very early stage companies, and have a clear idea of how you're going to operate with another founder exiting the company. So that would be in a nutshell. One is understanding what intellectual property is and what intellectual property you're creating in your company. And the other is understanding who is creating that intellectual property. And I'm going to start first with the first one. There are all sorts of intellectual property rights, which fall into place depending on the type of company you're running. Most frequently for software companies, we're talking about copyright, which is the type of right that is related to software products being developed. But it's also the case of trademarks. Whenever you want to register your name or your logo, or a combination of the name and logos you're using to promote your business. And in case of more particular types of companies, let's say more where the technical nature of the product being built is more important, and that's usually the case for, let's say, health tech and hardware products in general. You may also be touching upon the aspects of patents. So it's really important to first identify the types of intellectual property that are relevant for the business that you're running. Again, it usually comes down to copyright, which is the most relevant type of intellectual property right when you're developing software. And the second aspect is related to who is creating those intellectual property rights. Under Romanian law, and again, also potentially applicable in other jurisdictions, The owner of intellectual property is the individual actually creating that asset, which is protected by intellectual property, let's say by copyright law. So in order for your company to be able to get ownership over that intellectual property right from the individual that created it, that right needs to be assigned by the individual to the company in order for the company to be able to consolidate its intellectual property portfolio and be attractive for investors wanting to invest in the company. So in order to do that, you must be aware of who is creating what in your company. The idea of assignment of intellectual property, assignment of copyright from the individual to the company is also applicable in the case of founders creating intellectual property. Let's say founders that are developing the software that you're going to sell or you're going to license. And that's really an important aspect, because when you're a founder, but you're also working on developing the product, you have two different, let's say, qualities, which you balance between. The one is the quality of founder shareholder, so the owner of the company. And the other is the founder who's also working as a part of the team developing the product. The simple fact that you're a shareholder of the company does not mean that the company owns the rights automatically over everything that you create. So again, in that context, if the founder is developing the software, he or she also needs to assign that the intellectual property rights over the software created to the company. And again, that replicates to designers, to people doing content marketing, to the people running your blog, if the case, because all of them are creating assets that are protected by intellectual property rights. Again, the people creating the website. So have a clear map of who's creating intellectual property, who's creating assets protected by intellectual property rights, what those assets are, and be sure that everything that is important for you in running the business gets consolidated, so gets assigned to the company, and the company becomes an owner of it. And make sure you think about that beforehand, because there's also people churn, human resources churn in startups. So you need to be aware that it's going to be much more difficult down the line to be able to assign intellectual property rights from someone who left the company, because they usually have no incentive to revisit the problem once they're gone, and that might make for let's say a more difficult conversation than normal. So map this out as soon as possible. As a general note, you need to know that if something is not forbidden explicitly in the law, or is not particularly provisioned in a certain way, it does not mean that it cannot be done. So, for instance, in Romania, you have some provisions related to setting up stock option plans, but for public companies. That doesn't mean you cannot set them for private entities, so for startups which are not listed on the stock exchange or on other publicly tradable markets. You also need to take into account that most startups at the beginning are set up as limited liabilities companies, and under Romanian law, those can have up to a maximum of 50 shareholders. So if you come to a point where you're going to have more than 50 shareholders, you need to see exactly how you're going to structure assigning shares or granting shares to other people that you want to become shareholders in your company. And the way to structure it would be to see if you can set up an SPV which specifically holds shares for all the employees and all the collaborators who have access to shares in the company.
If you conclude the agreement with a company, the person that has the representation power and has the power to sign the agreement is the director of the respective company. So you should make sure that the person signing the agreement is the director of the respective company. If the person is not the director, any other person within a company might sign an agreement only by using the power of attorney. So you should see if the respective person has such a power of attorney when signing the agreement. Otherwise, if the agreement is not signed by the person having the representation right, the agreement might be deemed null and void. So you can lose the entire agreement.
And another really relevant aspect is the concept of vesting. Again, it's not per se regulated under Romanian law, but you can create a mechanism of deadlines and of conditions and criteria that needs to be met in order for the beneficiary of shares, so the employee or the collaborator, can gain access to those shares.
In an online medium, you can do that by publishing a privacy policy on your website. And this privacy policy should contain all the mentions that GDPR provides for. For example, it should contain the identification details of the company. It should contain the purposes of the processing. Why are you collect the data from the personal data from your users, and what do you do with the respective data? It should contain the legal basis for the processing. For example, you might need the data for performing a contract or for sending marketing communication, and in such a case, when processing the data for marketing communication, you have to obtain the consent of the user for receiving such communications. Also, you have to, in a privacy policy, you have to indicate the duration of the processing, how long do you store the data, and you also have to indicate the rights of the data subjects in relation to their personal.
It always makes sense to at least think about the legal issues you're going to run into, or you may run into, when you're starting a tech startup. Even if you don't have the time or the resources to solve them from the get-go, although that is, we encourage you to do that, it's also a good way, and it puts you in the top probably 10% of entrepreneurs that do that. It's a good idea to map the issues that you need to get solved, whether it's signing a shareholders agreement or getting your intellectual property in check and making sure that the company owns all the intellectual property it needs. Or if we're talking about having a template agreement that you're going to sign with the clients, at least list the things that you would need in order to be able to run a successful business. And once you get the time and the financial resources to do it, make sure you can and you start to do that and engage with a lawyer specialized in these ideas.